Representative Bojani.
Present.
Representative Bowers. Representative Darby.
Present.
Representative Harrison.
Here.
Representative Leach. Representative Christina Morales.
Here.
Representative Schatzline.
Here.
Quorum is present. Thank you, members. Just a reminder for anybody that's here, anybody present wanting to testify before us, you need to register at the kiosks that are located in the hallways behind the hearing rooms. If you require assistance in registering or testifying, please contact the committee staff and we will make sure to help you out. I do want to note that in our posting, we listed that we'll have a 3-minute limit on public comment. I'm going to have this high-tech device here to help us keep with that. I just want to be respectful of everybody's time. There's a lot of issues that we're going to be talking on, wide-ranging subject matter, but that way it gives everybody an opportunity. And yet that doesn't include questions that are asked of you. And so 3 minutes on a presentation, and then if we have follow-up questions, we can do that. Members, and I know I see members that have bills up, generally the process and the order we'll keep for everybody, just trying to keep notes, is seniority order for bills that we'll hear. Members of the committee, sorry, will go last. I will go very last if I have bills, which I do today. And we'll go seniority order within the members of the committee after members, non-members are here, so we can let people go about their business, right? That's always subject to change. If we got someone with 0 witnesses and we got someone with 20, which we'll try to make it work the best we can, but just generally for the public and for the committee members, if you're looking at the bills, that's how you can kind of anticipate that they'll up, and then we'll shift and change that. Like I'll show, like we just looked at these right now. Ms. T had a roll, but doesn't seem like she has too many witnesses on any of them, so we'll probably just move with hers first. Before I do that, though, let's see. I do want to refer some of the bills that we received to subcommittee. So the chair would refer the following bills to the subcommittee on criminal procedure: HB 303, HB 311, HB 322, HB 352, HB 394, HB 399, HB 401, HB 405, HB 412, HB 414, HB 416, HB 467, HB 504, HB 519, and HB 559. The chair refers the following bills to Subcommittee on Asset Forfeiture, HB 69. Okay. Let's get started. Chair lays out House Bill 247 and recognizes Dean Thompson to explain the bill.
Mr. Chairman, members, may I present the bill from this position?
Yes, ma'am.
I'm honored this morning to present this bill because we have a judge in the room, one of our former colleagues that I'm delighted to see. Welcome, Judge Phillips. Last session of the legislature, this bill was before us. And I think, if I'm not mistaken, we probably passed it out unanimously from the committee. Under the Texas law, individuals convicted of a crime generally have one opportunity to file a habeas petition challenging their conviction collaterally. People in prison often do this on their own without the help of a lawyer, and they fail to raise all of the relevant issues or fully develop them, so their applications are denied. This has become a barrier for conviction integrity units in district attorneys' offices throughout our state. When a DA's office investigates potential innocent cases and find evidence of a wrongful conviction, they can't rectify that conviction because of a previously filed writ application. This bill would allow the DA to waive the bar on subsequent writs when they believe, in their discretion, that the ends of justice will be served by allowing the court to consider a subsequent writ application. This bill gives district attorney's offices additional tools to address wrongful conviction. And I'd like to add that this bill was voted out of this committee unanimously and passed the Texas House last session 146-0. I will certainly appreciate your favorable consideration, Mr. Chairman and members. If there are any questions that I may answer for you, I'm available. If not, I reserve the right to close.
Yes, ma'am. Members, do you have any questions for Dean Thompson on this bill? Nope. All right. Then we'll figure out if I can work this. Chair calls Mike Ware. Okay. Hey, Mike. Welcome back.
Thank you.
I know you know how to do this, but your name, if you're representing anyone other than yourself, and your position on the bill.
Thank you. Good morning, Mr. Chairman. My name's Mike Ware. I'm representing I am the executive director of the Innocence Project of Texas, based in Fort Worth, Texas, and I'm the representing the Innocence Project of Texas on this bill. It seems
Your
extraordinary.
position on the bill?
I'm sorry.
Your position on the bill?
We're for the bill. I'm sorry.
Mhm.
It seems extraordinary, but a great deal of our weeding out of otherwise legitimate cases and a great deal of time that we spend on cases is figuring out how to get a court to hear the merits of a very meritorious claim that is procedurally barred because it's a second-in-time claim. In other words, this individual may have filed something on their own or something may have come up and they've already had one writ denied. Therefore, there are statutory obstacles to them filing a second-in-time writ. Many times, those statutory obstacles can't be met. Now, let me give you an example. We've had 28 men and women that we've either exonerated or freed since I co-founded this nonprofit back in 2006. The last one was about 10 days ago out of Bexar County, Melvin Quinney. But we've got one coming up, James Reyes, in which the Odessa Police Department and Ector County District Attorney's Office has done an excellent job in investigating this cold case. Our client was wrongfully convicted, is completely innocent of a murder back in 1982. And thanks to the excellent work of the Ector County DA's office and the Odessa Police Department, he is likely going to be exonerated. Now, what if he had filed a prior writ that we could not meet the procedural burden on? Our hands would be tied. What this does is it allows a district attorney's office, if the district attorney himself or herself signs off on it, to waive this procedural bar and allow a case to be heard on the merits, which otherwise they don't have the power to do. It doesn't mean they have to agree to relief. They could still contest whether or not the merits merit relief, but at least it would allow the minister of justice, the elected district attorney, in their judgment to waive a procedural bar and allow the merits of a case to be heard. Otherwise, the Court of Criminal Appeals is likely to say, you don't have the power to do that. It's statutory. This obviously innocent person is procedurally barred from bringing a claim. Happy to answer any questions.
Mike, thank you very much. Members, do we have questions at this time? Nope. Thank you, sir. Chair calls Benjamin Wolf.
They can still contest whether or not the merits merit relief.
That was my favorite part too. Do you have prepared remarks, or are you here?
Just
reading?
oral,
Okay.
brief oral remarks.
Go ahead.
Good morning, Chair, members. My name is Benjamin Wolf. I'm the Director of the Office of Capital and Forensic Writs. I'm testifying on this bill. The Office of Capital and Forensic Writs is the Capital and Forensic Science Post-Conviction Public Defender in the state of Texas. represent a number of individuals, or about approximately 70% of the individuals pending in capital initial post-conviction proceedings, and represent non-capital incarcerated persons incarcerated on non-capital offenses in cases referred to us by the Forensic Science Commission. To briefly dovetail off of the remarks of Mr. Ware, in our forensic practice, we get cases referred to us by the Forensic Science Commission, where the Forensic Science Commission, which is a great entity attached to the Office of Court Administration, will review cases, determine that the science is the forensic science used in the case was bad, and refer them to us. And these are people who've been incarcerated for sometimes decades without lawyers. And in Texas, there's not a right to post-conviction representation on non-capital cases. And so that means that persons incarcerated will oftentimes file pro se writs without the assistance of counsel. And those pro se writs may have preclusive effect and impose procedural bars to later litigation. And so that's something that we're having to deal with in these cases where there are potential innocence claims. There's strong science that potentially affected their convictions, and the district attorney may want to see that justice is done, and the current law makes that difficult. Happy to answer any questions. Otherwise,
No, thank you, Mr. Wolf. I appreciate.
Thank you.
Appreciate your time being here. Do we have any questions before we let them go? Nope. All right. Thank you, sir. Is that what we have? Is that? Is there anyone else wishing to testify on, for, or against House Bill 247 at this time? If not, the chair recognizes Dean Thompson to close on her bill.
Mr. Chairman, witness, and committee, thank you for letting me present this bill.